morning, ladies and gentlemen of the world, jurors. I'm making this video just to find out why terrorism takes place in the United States of America. As you see in the last couple of days, there were so many people being killed. And whenever something happens in any country, we have to find out the causes, not the effect. That's why I decided to bring this matter to the attention of the world community. I have never been, nor I will never be a terrorist. But I am somebody who wants to expose terrorism taking place in the American system. The system of justice, the courts, and the administration and whatnot. So this video is designed to tell you people around the globe what is happening. In my case, which is going on 38 long years, 38, okay? It is always good to know the facts and what is happening with the various agencies designed to protect people. It all started in 1981 when I was working for AT&T, one of the most powerful corporations in the world, so powerful politically and economically. They gave me a Monday morning a $5,000 merit increase and a fully satisfactory job performance rating. We were 1,500 people working there to defend a case the US Department of Justice had brought against them to break their monopoly. So after giving me a merit increase of $5,000 on Monday morning, on Friday I was fired. Fired. No reason at all. No justification for firing an employee who worked for them over 7 years. You got to understand. You got to understand the facts here. The defendants may try different tricks. They don't have a single answer. Pursuant to the rules, I filed a complaint with the US Department of Justice called EEOC, Equal Employment Opportunity Commission, who refused to investigate. I'm going one step ahead. The defendants, AT&T and Michigan Bell, one of its then subsidiaries, refused to pay me the benefits due to me under the agreement. 1,500 of us working in Orlando, Florida. We were on a contract, each one of us, 1,500. I was the only person of Indian origin working in the legal department as a legal analyst. They literally held me and my then children aged 3, 7, 9 and 11, and my father, dependent father who came from India, and my wife to economic ransom and blackmail. You have to understand the facts here. They have a contract to sell my home as soon as they transfer me back to the company I was previously working. They don't want to do it. They are supposed to pay me 8 years' salary if they terminate an employee, which they don't want to give me. They are supposed to give me all the other benefits, all in the agreement. They refused. They literally held me to economic ransom and blackmail. The purpose was, they have got 1,500 others, so once they terminate a person who is considered as a a minority, Pacific Islander, Indians are considered as a minority, pursuant to the US Department of Justice guidelines. Once they fire me and a minority guy, they can scare other employees. That was the objective of the employer. But their plan misfired. After holding me and my dependent family to economic ransom and blackmail for several days, I was forced to sign a certain release, a 2-page release. While I was in Detroit, Michigan, looking for a job. I had no option because I am signing this under duress to feed my children. You understand? When I came back, I filed the EEOC complaint, which they refused to investigate as required under the law, and issued me a right to sue letter, and I sued these companies at the Middle District of Florida in Orlando. Defendants promptly moved to dismiss the case, interposing release as an affirmative defense, while admitting they had illegally terminated. The judge then, John A. Reed, who is dead now, he denied the defendant's motion to dismiss, citing a US Supreme Court case known as Alexander versus Gardner, Denver, footnote 50. The holding in that case, decided by the US Supreme Court, is an employer can obtain a release from an employee provided it was given by the employee freely, voluntarily, and knowingly. If there is no freely and voluntarily execution of a release, it is invalid, according to the Supreme Court in Alexander versus Gardner, Denver. So the judge, John Reed, who is dead now, as I told you, he denied the defendant's motion. And he said he will conduct a trial within the trial under Rule 42B of the Federal Rules of Civil Procedure to determine whether that 2-page release that I was forced to execute on August 25, 1981 in Detroit, Michigan is valid or not before considering my claims under ADEA, Title VII, breach of contract, other claims. Defendants do not want me to have a jury trial or a bench trial. You understand the gimmicks? This is where the gimmicks start. So, defendants attempted to bribe my my counsel, a gentleman from Chicago, who is from Kerala, India, from Pali. They tried to bribe him by offering him, through the Bar Council of Chicago, Cook County, a judicial position when I was sitting in his office for consultation. I am the one who picked up the phone from the bar. Then I gave it to Mr. Kapil, and he said no, he is not interested in a judicial position. Then the defendants attempted to give him other cases so that he can build them. That's another tactics. You have to understand the tactics employed by this mafia corporation. That didn't work out. Then they started threatening him, saying that they are going to make this expensive so that being a solo practitioner, he will not be able to handle it. And to prove that, they propounded 1,300 separately numbered interrogatories or requests to admit, which he thought was overly broad and burdensome, and yet he answered the same. And since I couldn't afford to pay my counsel huge retainer, which I could afford, so we mutually agreed to have his services terminated, and I took over pro se. Mr. Kapil was subsequently murdered. I have serious doubts whether the defendants were indirectly involved or not. I don't know. I came to know the death of my counsel 2 years later because I had moved to New York by then. Now, this judge I thought was very honorable and honest. So what they did was, you have to understand the tactics deployed by this company. They secretly went and hired this judge's law clerk, who is his close friend of the judge. Without disclosing this person, her name is Anne C. Conway. She was a private attorney at the time working for an international law firm called Carlton Field, Emanuel, Cutler and Smith of Tampa. She was hired in as co-counsel solely to influence Federal with this judge and to dissuade him from not conducting the proposed evidentiary hearing. I didn't know at the time this woman was the judge's former law clerk, or they are close friends, and she was recruited by the defendant solely to influence the judge. So, after this woman came on board as their counsel, the judge will not conduct any proceedings in the open court. He wanted everybody to come to his chambers and he will bullshit for a few minutes and that status conference will be over. And in one of these status conferences, he held before a court reporter that there is a triable issue of material facts remaining in the case. And under the rules and the case laws decided by the US Supreme Court, a summary judgment cannot be granted and there ought to be a trial, which the defendants do not want. So, few months went by, the judge will not do anything, he will not conduct any hearing, nor provide me discoveries. I begin to suspect there is some hanky-panky going on between this woman, whom they secretly brought through the back door to be the defendant's counsel, to influence Federal with this judge. I sent the judge a questionnaire consisting of 20 questions, and as soon as he got the questionnaire, he immediately picked up the phone and called me to New York, where I was living. You have to understand, a federal judge, sitting federal judge, he cannot, under the canons of ethics, cannot even call a lawyer. He is calling me, a non-attorney, a pro se non-attorney, to New York to discuss, to say that he doesn't want to give me a written answer to my questionnaire, but he will give an answer over the phone, and at my request he admitted that I can tape record. Thus, such a taped telephone conversation held between me and the judge admitted this woman was his former law clerk, he is a shareholder of this company, he had worked for the same company, one of his subsidiaries called Southern Bell Telephone Company in Florida before he became a judge. And the most important bombshell was he was meeting the opposite party's counsel at her home, his home. They were meeting in Atlanta, in private. This is the most damning admission that a judge can make, a federal judge of the United States. I reported him promptly to the FBI and to the Chief Justice of the US Supreme Court. Within a few days, the judge recused from the case and resigned in disgrace. He is now dead. Then, you have to understand the whole facts here. Under the rules, if a judge dies, become ill or become unsuitable, fit, or whatever it is, the case has to be reassigned to another judge in the same court. Here what they don't want it. The defendants do not want any of the 6 judges stationed in Orlando to hear the case. They secretly made a deal with another judge by the name Terrell William Hodges of Tampa. Tampa judge had no personal jurisdiction over me, who lives in New York, or geographical jurisdiction because I never lived in Tampa and the cause of action did not arise in Tampa. He issues me an order to attend his court in Tampa, and when I went there was a notice on the notice board saying that additional security is required, no hearing on that day, as if I am a wanted criminal appearing in a criminal court. I am a civil litigant in a civil case. Why this judge is afraid of me? I don't even have a parking ticket to my credit. The courtroom was packed with U.S. Marshals, gun-wielding U.S. Marshals, courtroom deputies and undercover agents, as if I'm a terrorist. I'm not, as I repeat, I didn't even have a parking ticket, okay? I'm a perfectly law-abiding citizen. They wanted to make me a terrorist. That's the intent here. This judge issued an order saying that, Mr. David, I'm going to conduct these proceedings pursuant to the rules and the standard laid down by Judge Reed under the same rules and parameters. Did he conduct a hearing? No, folks, because they have no case. They have no case to prove I quit the job freely, voluntarily, and knowingly. So they were planting another case law from Michigan. To accomplish that, they kept my case in a state of suspended animation and hatched a case law from Michigan, another state. And that Michigan court issued a per curiam unpublished opinion. As soon as they got it, so this judge was sitting doing nothing until 1995. You understand? The judge was doing, until 1985. From 82, 83, 84, 85, doing nothing. You understand the name of the game here? And this Michigan case, as soon as the defendants obtained a copy of this per curiam unpublished order and opinion, which has no precedental value at all, submit to the judge under the rules, under Rule 55 of the Federal Rules of Civil Procedure. The judge is supposed to give you a notice of hearing, date and time set for the hearing, provide me discoveries. None of these were followed by this judge, this crooked judge, Terrell William Hodges. So he issues an order directing the clerk of the court to dismiss the case without prejudice. It's a marked word without prejudice. It's a legal expression which many of the lawyers in America don't know. I didn't know either. The clerk of the court, under the puppet of the corporation, his name is Donald Brown. He alters the court's order as a dismissal on the merits. And grants the defendant their cost and expenses. You understand what is going on here? The judge issues an order who has no authority to be in the case, The clerk alters it, and the defendant's Supreme Court licensed lawyers, Pete, Wolf and Cinnabar, and Arnie Conway, and the defendant's entire in-house counsels file a false jurisdictional statement. Stating the United States Court of Appeal has jurisdiction to hear the case pursuant to USC 28 U.S.C. 1291. That statute says the Court of Appeal has jurisdiction to hear the case if it is from a final decision. You understand the gimmicks here? They pay the clerk of the court in the United States Court of Appeals, and he accepts the case, although the Court of Appeal had no jurisdiction to consider an interlocutory order. And then they planned this with the 3 judges in the United States Court of Appeals. One was Robert Vance. He was bombed and murdered in the same year by another litigant by the name Leroy Moody. Moody was executed, I think, a couple of years ago in 2017, after spending a lot of time. Every judge in the court recusing, and then they have to move to another place, find him guilty, they executed him. So what Moody did was send a bomb in the mail, okay, to kill the judge, because he knew these judges are all corrupt. Second judge, his name was Clarence Allgood. Clarence All. He took a gun and shot himself, according to the press report. The public knows nothing about it. The United States government or the courts do not want the public to know what is happening there. Okay, people listen to me. I'm not a terrorist. I'm not trying to be vindictive against judges who are dead. What is happening in a court of law? You pick the panel. The third judge was a black guy by the name J.L. Edmondson. This 3-judge panel affirmed no explanation for affirmation of a judgment from a court below. I moved to the U.S. Supreme Court with a petition for writ of mandamus. In the meantime, before I moved to the Supreme Court, I found out while working in a New York law firm the difference between a dismissal without prejudice and a dismissal on the merits. There's a mountain of difference. This was understood while reading the law journal. So I made a motion means a petition, as we call in India, a motion. In America, everything is a motion. Motion for summary judgment, motion to dismiss, motion for everything is a motion. M-O-T-I-O-N, motion. So I made a motion to that Judge Hodges, to correct the error made by his clerk, because the court's order was to dismiss the case without prejudice, which he altered as a dismissal on the merits. Judge Hodges had no option but to correct it, telling in his order dated January 30, 1991, the clerk had goofed, which we call as a clerical error. You understand the difference between a clerical error, something intentional, which is done to assert the jurisdiction of the 11th Circuit. Case or scheme. This clerk was fired because he was doing this kind of hanky-panky, and 2 other judges, Patricia Fawcett and another judge reported him as incompetent, so he was fired, this clerk, Donald Brown. Now, when this judge made the amended order, which is telling the court had no jurisdiction because it's an interlocutory order, this case goes to the same judge, J.L. Edmondson. The rules require, I had made a motion under Federal Rules of Appeal Procedure Section 35, which says I can demand an en banc hearing. It means the entire court should rule on to recall mandate issued by them in 1970, 1969, earlier. Okay? So, this judge, who is again on the payroll of this corporation, he gets the file. This judge was found ineligible, disqualified by the 11th Circuit rules effective July 15, 2012. How can a judge who is disqualified can rule on a case in which he ruled against me? You have to understand, people with the common sense. I'm trying to tell the lawyers, educated people in the community, the intelligentsia, the world community, to understand the gimmicks going on in the United States courts. He denied the motion arbitrarily and capriciously, although he had no right. The rules require, the FRAP 35 require review by 3 active judges, not by a judge who is disqualified. And he ordered the clerk of the court not to accept any papers from Mr. David on this closed file. Understand? Closed file. The fact that they closed the file is not my fault. They can reopen the file because the file is there in the court. I made a motion, second motion under Federal Rules of Appeal Procedure, seeking en banc hearing again. Hi guys, under the scheme, is all scheme worked out by the defendant in concert with the clerk of the court and the 11th Circuit. So, the motion that you sent to the clerk of the court never circulate amongst the other judges. It only goes to this particular judge who is disqualified. He denies again on his own along with another judge, Judge Marcus. Then I filed a petition before the US Supreme Court seeking a petition for writ of mandamus. The mandamus is asking the court to direct the clerk of the Judge Edmondson to recall mandate. I'm told it's all the secret, top secrets, because the Supreme Court only grants 80 cases out of 10,000 filed in a given year. The rules of the Supreme Court of the United States, is a rule, it says granting a writ of certiorari or a mandamus is a discretion. You understand? Discretion, it means you have no right to tell the court the hanky-panky going on and they will only consider 80 cases. So 9,920 cases, howsoever meritorious they may be, they are rejected. In India, we have 31 judges in the Supreme Court. They are going to add 2 more this week. So we have 33 judges in the Supreme Court of India. But in the United States Supreme Court at that time, they had only 8. They were fighting for the next judge for a year and a half in the Senate. You understand the gimmicks going on. There was one judge died, another judge resigned, so there was a second fight for the next judge. Why there is a political fight in the Senate to appoint a judge or a justice in the Supreme Court? So my motion, my petition for writ of mandamus was automatically rejected by the clerk's office. I don't think the justices or their law clerks ever read the arguments I presented. The sole issue, the argument I presented was, when the court had no jurisdiction, its judgment is a legal nullity. It's a legal nullity. So here, Judge Hodges had no personal and geographical jurisdiction. He makes a ruling, his clerk alters it, goes to a panel of the defendants choosing at the 11th Circuit, which they affirm. Okay? So I sued I didn't say I sued, I filed a petition against the United States government, Solicitor General, pleading Judge Edmondson and the district judge as parties. No response was ever filed by anyone admitting indirectly what I am saying is right. But the letter I am getting from the clerk of the court is a petition for writ of mandamus denied. I have no verification. None of these papers are signed by justices. All that you get is a printed piece, one piece of paper in which they put in the name of the parties and automatically press the button, it will say denied. You understand the gimmicks in the US Supreme Court I am talking about? I filed yet another petition in the Supreme Court, again seeking to review the decision, because the Supreme Court had held in so many cases, not one, as well as the Circuit Court of Appeals in different jurisdictions, that when a court has no jurisdiction, its judgment is a legal nullity. Same thing I am arguing. I am not a PhD guy. I didn't go to Columbia or Yale. I am only bringing to the attention of the US Supreme Court, you apply the same standard you applied in other cases. Finally, folks, the US Supreme Court in case number 16-9624 we are going to show you a complete copy, which is a 5-line order. The Supreme Court said, my petition to proceed in forma pauperis is denied, and the petition for mandamus is denied again. But the next sentence says, unless petitioner pays the docketing fee and file a petition pursuant to the rules. Okay? So the clerk of the court didn't read. He only read part of the sentence. In a 5-line order, he only reads first 3 lines and then he ignores the rest, which permits me to file the petition. The first clerk, by the name M. Blarlock, she sent the whole thing back to me. It cost me 1.5 lakhs to prepare and send it by express mail, 40 sets of my brief. She sent that those brief back to me in 4 boxes and my docketing fee of $300, saying to do what is stated in the court's order, which is what exactly I have done it. So this idiot, knowingly or unknowingly, she looks at the old case, 15-9100. You can see from her letter. She is not looking at the correct case. She is looking at the old case, sending me back the papers which I sent to them pursuant to the rules. Then I sent the papers back to, I didn't send the papers, I sent the check back to the Chief Justice of the United States Supreme Court, John G. Roberts, requesting him to direct the clerk's office to accept the petition and give me a case number. Then, apparently, Chief Justice sent the check to the clerk's office. I get a letter from another clerk. His name is Jeffrey Atkins. He only reads first 2 lines. He failed to refuse to read the 3 and 4 and 5 lines, which permitted me. He says, your petition for writ of mandamus was denied by the court. The case is considered closed. Who is he to tell me the case is considered closed when the court specifically, clearly state, unless I pay the fee and file the petition. I wrote another letter to the chief clerk. Chief clerk, his name is Scott Harris. He refused to respond, knowing full well what I am saying is right. Then I was forced to file a complaint against the chief clerk for failing to do his duties. He went to the disciplinary committee of the District of Columbia in Washington, where he was licensed, and they manipulate and say through their assistant counsel, not the chief counsel, assistant or deputy counsel, a woman by the name Becky Neal, that they can't investigate this guy. Okay? They can't investigate. I sent a complaint to the US Department of Justice. I got a letter from the Inspector General of the US Department of Justice in an unsigned letter. Not 1, 2 letters. They have no jurisdiction. Why the US Department of Justice doesn't sign a letter sent to a litigant, a party litigant? No name, no signature. Is the US Department of Justice is telling the truth? No! They are afraid of this corporation which was found guilty by the US Department of Justice themselves and fined them millions and billions. You see, so there is no remedy under the law for me to get justice. I was forced to file a complaint with the United Nations Human Rights Commission. That is where the case now stays. Now, a few days ago, I got a letter from the acting clerk, acting chief judge of the 11th Circuit, finding all these people not guilty. All these people not guilty. They have not done anything wrong. His complaint, his report is completely distorted. Because when I say one thing, he says, forget about it. When I say another thing, he says, no, forget about it. He is putting words into my mouth, trying to help these 3 crooked judges. Terrell William Hodges of Tampa, he is now moved to another place, I believe, somewhere in Florida. Annie Conway, who was elevated to the federal bench and to the Sutherland's court in DC as a judge there, and the Judge Jael Edmondson, they have not done anything wrong. Now I have to respond to that motion which I am working on, because regardless what they rule, The Supreme Court has already overruled them by allowing me to file the petition. And the matter is now currently before the United Nations. Folks, why I said all this was why people resort to violence in America. It is not Mr. David alone. There are hundreds and thousands of people who are denied justice in the kangaroo courts of the United States, and the frustrated and angry public, they have no recourse except to resort to violence. I never ever supported violence. I am a peace-loving person from the country of India, where Mahatma Gandhi, its leader, taught us the principles of ahimsa, non-violence. So I am in India for the last 10 years fearing for my life, because this mafia corporation can do anything they wanted. Yeah, I may disappear one day from the planet Earth, like the reporter Khashoggi in Saudi Arabia was made to disappear. Okay? Folks, no wonder we have terrorism in America, unless the US government, the agencies, 3 agencies of the government, take immediate steps to address the questions that I am presenting. We will continue to have violence every day in America, every day. I may pass by, I'm 80, but my future generation, my children and my grandchildren, and your children, your grandchildren who live in America will face the same consequences, same issues, same problem. Thank you, ladies and gentlemen.